He doesn't have to continue on. If you don't have a complaint, you don't have to do it.
Justice Hyde, you can get a chance to ask your question. Are you satisfied?
I am. Thank you.
Then thank you.
Thank you, Justice.
SJC-11745, Commonwealth v. Brian Freeman and another.
Which one?
Good morning, Your Honors. Barbara Cabin on behalf of Brian Freeman and Mika Martin. With me today is Attorney Craig Bartholomew. In June 2013, two boys, age 17, were charged with an alleged assault and a theft of an iPhone and a pair of sneakers. But unlike similarly situated 17-year-olds, they are being proceeded against as if they are adults based on the fact that they were charged on the wrong side of September 18, 2013. This case basically challenges the under-inclusive classification that arose out of this court's decision in Watts.
Ms. Cabin, if you're correct, what, as a practical matter, I mean, now it's February 4th, 2015.
Correct.
And September 18th, 2013 was a long time ago.
Correct.
So what, I understand your clients have not, I mean, they remain able to be dealt with, but are you saying that all the people who were, whose cases were pending in the district or superior court as of the effective date of this act, and it's gone to, you know, whatever, it's been disposed of one way or the other. They all need to get undone? They would all need to get undone?
That's not what I'm saying, Your Honor. And obviously there are issues here. In some of those cases, if the when you decided Watts, equal protection was not before the court. Right. It hadn't been raised, it wasn't argued. Most of the cases have been resolved. I know of these two defendants and one other. Maybe there are a couple more out there. But the fact is that if if equal protection was not raised before the district court or the superior court, and they resolve those cases, I would argue that they have no basis to come back. If equal protection was raised, I would argue that, yes, maybe they do have a basis to come back before you. Because I'm arguing that, in fact, this under-inclusive classification was based on impermissible criteria, and that, therefore, these defendants are being denied equal protection of the law. And so, yeah, it does create an anomaly for you, and it does create an anomaly for some of those defendants. But I think in most of the cases, it will not occur because I think most of them did not raise the equal protection issue, and will have waived it.
You spend a lot of time in your brief discussing whether or not children are a quasi-suspect class. But why is that at issue? I mean, doesn't your argument apply to anyone who has where there's a change in the law and they're now differently positioned?
There are a couple of different parts to that. We raised the issue of quasi-suspect class for juveniles because I think it's time for the courts to start to think about the fact that juveniles are different, and not just different for the Eighth Amendment due process, but in fact for equal protection. But if you're asking me, could this case just be decided under rational basis review? Yes. We don't need to go to intermediate scrutiny, which would be demanded if you do determine.
And how would you win after Watts on rational basis review? Because Watts says there's a lot of good reasons why it was rational for the legislature to do what it did to avoid having every person having new cases before the juvenile court who was over 17 and less than 18.
Well, I think I addressed each of the issues, and I'll go through it again. But I think that the criteria that was used by the court really should not withstand further scrutiny. I understand that, the decision was made, but I don't think a court is required to perpetuate a wrong that resulted from its decision. And in this case, these are the reasons that you looked at. You said, okay, it's basically there are substantive issues, so therefore there's a presumption of prospective application. I would agree that, in fact, the juvenile court jurisdiction involves substantive rights, and that's the fact. But there's a second part of that clause, which that basically what was argued, that there wasn't a clearly expressed legislative intent to apply it to the pending cases. I would argue that, in fact, that was not the case. What was clear was that it did not apply to cases that were closed. The legislature addressed this. But when a legislature changes a law, we presume that they understand what the state of the law is from your case law and from the statutory concerns. And in Commonwealth versus Nanny, in Metcalf, in a whole series of cases, it has been clear that the dispositive fact is the age of the juvenile at the time of the crime for establishing jurisdiction. And in fact, we've never really addressed pending cases. And this law, this amendment that the legislature did not address the pending cases. And if we look at what it's reasonable to assume that they presumed that, in fact, if the kid was 17 and they still had a case pending, it would be their age at the time of the crime that would dictate the outcome of which jurisdiction they would go to.
It seems that unless we walk away from Watts, you can't win on a rational basis. You need something more to win here, correct?
I think even under rational basis, there is a serious question about the reasoning that the court relied on in Watts.
No, but the premise of that question was, unless we walk away from Watts, you don't win on rational basis.
Right. Basically, tell us how you win if we're not prepared to walk away from Watts.
You're right. I can't win unless you're prepared to walk away from Watts. But I'm arguing that you definitely should be walking away from Watts because, A, the presumption of prospective application as defined was wrong. The phrase that you relied on in Section 74, no criminal cases shall be begun, that also should not have been dispositive of this case because the fact of the matter is Section 74 has never been about the jurisdiction of the juvenile court. Section 74 has always been about how you transfer cases from the juvenile court to the adult court, and that phrase, no criminal cases shall be begun, did not say anything about pending cases that had already begun. And if you look at sections 53 through 55 that have always established that the age at the time of the crime is dispositive, that section should not be determinative. And then the last thing, and in fact, if you look carefully at the decision in Watts, what most of the decision spends a lot of time on is looking at the administrative inconvenience that would arise, that there would be motions that would have to be challenged, whether it was interested adult, discovery motions, and that the juvenile court would be overburdened. And in fact, that was inaccurate, and it was.
You don't look at retrospectively, geez, those concerns, they didn't really turn out that way. That's not the way you look at rational basis. You look at, were there concerns at the time? Were they rational? Right? I mean, at the time they were rational. So you look back and say, well, it really wasn't that many people. It probably could have been managed in a better way. That's irrelevant.
Okay, it may be irrelevant, but the fact of the matter, A, they are handling it without any of those increases. But the fact of the matter is, if you look at Supreme Court decisions, they have routinely said that administrative convenience and ease are not valid reasons.
But those are in strict scrutiny cases, not in rational basis cases.
Well, the issue of what is rational basis in Massachusetts is really open for question because, in fact, what the Commonwealth argues is that, under rational basis, you're compelled to accept the legislative determination. But in fact, if you look at the way you've analyzed rational basis cases in the past, you've engaged in a very detailed balancing test that I don't think occurred in Watts. Basically, you really didn't...
We weren't looking at it in terms of rational basis. We were trying to discern what was the legislative intent. I mean, it's a very different lens through which, we were trying to figure something out.
I agree, and that's why I think it's time for us to basically say, okay, Watts was wrongly decided, because
It's a different question, that's all I'm saying.
And I'm saying, yes, equal protection wasn't before you, but now under rational basis review, you have an opportunity to say, okay, we looked at it, and we basically didn't engage in the balancing test that is required by equal protection. That's the difference.
And what's being balanced here?
What's
mean, there are
being
no
balanced?
constitutional rights being balanced here.
No, there are important rights that have to be balanced, that juvenile court jurisdiction bestows upon kids important rights. They're not fundamental rights, they're important rights. And that's why the quasi-suspect classification is so important for kids.
We've never, a quasi-suspect? They're a suspect class? We've never said they're a suspect class, ever.
I agree. What we've always relied on in a knee-jerk position...
They're a class that needs to be protected, and the legislature can make distinctions in order to protect them, but that doesn't make them a suspect class.
It makes them a quasi-suspect class because what we really want to ensure is that whenever laws impact them, there's an adequate balancing test that actually looks
And
at the
who is to do
ramifications.
this test?
The
The
ju-
legislature.
No, they can...
There are no constitutional rights in question. There's no right to be treated as a juvenile.
Well, you know, it's really interesting. I think if we look at what's happened, you know, in Wayne W., the court had said that, in fact, the difference in the transfer proceedings, there was a challenge in terms of under equal protection and due process, and the court, relying on Stokes v. Fair, said there is no right to any preferred treatment as a juvenile offender. Well, now the landscape has changed, okay? Since the 70s, the 80s, there is now a right to preferred treatment as a juvenile offender. When we look at all of the cases, Roper, Graham, Miller, this court's determination in Diachenko, where even discretionary life without parole is not on the table
That's in the
anymore.
context of cruel and unusual punishment.
Right, and in the Supreme Court looked at JDB, which is a Miranda case, and they did it under due process. The times have changed, and the characteristics of juveniles, the distinguishing character of juveniles, are such that it is time to really take a closer look at this. And if we can say that juvenile status matters under cruel and unusual, if we can say it matters under due process, why shouldn't it matter under equal protection? I don't understand why those are that significantly different. And when we don't, in Massachusetts, we haven't used quasi-suspect class status, but you have engaged in rational basis review with, some of the law review articles talk about rational basis review with bite in Massachusetts. That, in fact, you have engaged in that weighing and that balancing of characteristics. And although you haven't used quasi-suspect or intermediate review labels, the type of analysis that you've engaged in, whether it was in Armont when there were two classes of prisoners that were created, and you started looking at the various elements of what that would mean, and when the Commonwealth said, well, we can counter the differential treatment by looking at a different section, you engaged in a balancing test and you said, no, that doesn't work. And in Murphy, where there was the compensation case where basically, workers' comp case where the individuals who had hired attorneys suddenly had to pay a filing fee, you looked back and forth at the balancing of that and you said, that makes no sense under the humane elements of it. Many of those cases are decided not just by the knee-jerk rational basis review as if the legislature says it, that's good enough. You engage in more detail.
But we're talking about the prospective application of a criminal statute, right? Talking about the prospective application, essentially, of a criminal statute.
We're talking about prospective application or not on a jurisdictional issue of juvenile court jurisdiction.
And isn't there a presumption that these such changes are prospective unless specifically indicated that they shouldn't be? I mean, if you're saying we should change our view of juveniles, well, then any juvenile who's been treated as an adult, maybe we should go back and change all of that, too. The legislature hasn't suggested that.
No, what I'm saying is that the fact that you're hanging the whole argument on whether the legislature expressly stated this applies to pending cases is just not broad enough, because in fact, if you look at your own case law, it has always been that the age of the juvenile at the time of the crime.
We've decided what the legislative intent was. You're saying, okay, well,
I'm
that
saying you made a
violated
mistake.
rational basis. Their intent was no good.
I'm not saying their intent was no good. I'm saying that the interpretation that you attributed to their intent was no good. This was a reported question of law by a Superior Court judge who basically said, if you say Watts doesn't apply to pending cases, doesn't this raise an equal protection challenge? And I'm saying, yes, if you look at it from that equal protection lens, There are enough questions that should be raised here. And although it only applies to a few people, and it may open some doors with some other cases, the fact of the matter is that these two juveniles are entitled under Equal Protection Challenge to have you look at this seriously and really say, okay, they are similarly situated, and the only fact that distinguishes
The date of the crime.
It's not even the date of the crime, it's the date of the charge.
Date of the charge, well.
Which is
so
basically totally up to the prosecution.
We do, usually it's fairly closely related to the date of the crime.
True.
Okay, so what's irrational about that? Using
Because
that
when
as a
you
cutoff
because
date?
when you looked at this is the categories you created. Okay, if a juvenile, 17, not a juvenile, let's say a 17-year-old committed a crime on or after September 18th, they were covered. They changed.
Case will go into the juvenile court.
Went to the juvenile court. If they committed the crime prior to the September 18th date, but were not charged until afterwards, they were still entitled to go to the juvenile court. The only group excluded were those who basically committed the crime prior to and were charged prior to. They were excluded. And if their case was wrapped up, the legislature was clear. It's retroactive. We're not opening that door. They never specifically addressed the pending cases. And based on precedent, I can make the inference as easily that, in fact, they assumed that a 17-year-old is a 17-year-old. And based on age...
You can make that case, but we've already decided it, haven't we?
You decided it without considering equal protection. That issue wasn't before you.
But legislative intent was.
And I think it's worthy of a second look under equal protection to look at legislative intent.
All right, thank you.
Good morning, Your Honors. If it please the Court, Donna Petalano on behalf of the Commonwealth. My sister and I actually did make all efforts to get this case in front of you before Watts so that you would be able to decide both questions at the same time. And that's important because when Judge Ball reported the question, she didn't have the benefit of Watts.
Well, what happened? I mean, I'm not blaming you. That's too bad.
The clerk's office didn't assemble the record as quickly as we would have liked. And there was a race to get to you, and we lost the race, unfortunately. But we did make every effort at the time, and Judge Ball was very much on board with helping us get that record to you, but unfortunately it didn't happen that way. So that's the story of why Watts was decided without deciding the equal protection. As to the practical effect of a decision in this case, although there are many cases below that didn't raise equal protection, I think it would still trigger subject matter jurisdiction questions, and all of those cases that were disposed of that my sister said would have no practical effect, I think that if I were a defense attorney, certainly I would be filing a motion to revisit those cases, those convictions, those pleas.
Based on...
If this court decides that Watts was decided wrongly. But you can't do that here. Watts was very clear. This was not a knee-jerk reaction, rational reflection of the jurisdiction of the juvenile court. The legislature took very much testimony, were very careful in considering what the effects were. They had testimony about how their decision, when they passed the act, would affect the cases.
Was there testimony about this specific category of juveniles who had committed the crime and were not charged as compared to those who had committed and were this very...
No, Your Honor, but there was lots of testimony about how the courts would have to deal with what the legislature was concerned about.
Yes, I do remember that. Thank you. And how many people, if you recall, are in this little category?
I don't know, Your Honor. And the other issue is, since Watts was decided, there may have been many cases that have been disposed of, either through guilty pleas or trials. So I don't think it really matters. What matters is what the legislature considered before they passed the act, how come they made the line drawing that they did. Unfair doesn't mean unconstitutional here. The legislature took everything very carefully considered, and they made a decision. A statute has to begin at some time, and they made the decision here. And unfortunately, inequities always occur, and inequity doesn't mean unconstitutional. We ask that you answer the reported question in the negative. If there are no further questions, the Commonwealth rests on its brief. Thank you.
Thank you. And we'll take our morning break.
All rise.